We have this massive cultural movement toward a culture of death, whether that's abortion or physician-assisted suicide. So not only how do we stop it, but like how do we put a stop to the bad practices, but how do we fund good alternatives is a really important question that is right within the scope of the proper role of government. Welcome to the Napa Legal podcast. I'm Frank DeVito, Senior Counsel and Director of Content at Napa Legal.
And I'm Joseph Clement, Content and Program Manager at Napa Legal.
You're listening to the Napa Legal Weekly Podcast, where we explore religious liberty from the perspective of faith-based nonprofits. This week, we'll be covering a case involving the free exercise and free speech rights of a physician assistant in Michigan, then a bill pending in Congress that would expand palliative care access as well as research and help combat the culture of death brought about by the growth of physician-assisted suicide, which is a topic we've been covering quite a bit recently. And then we'll finish up with coverage of a new series of grants by the Department of Homeland Security for religious organizations to bolster their security efforts. So let's jump in. All right, the first case, this is out of the Sixth Circuit. It involves a physician assistant named Valerie Kloosterman. So Ms. Kloosterman had a pristine record of over 17 years as a physician assistant. Her employer, the hospital she was working at, became a subsidiary of Michigan University, which is relevant because that means she's now working for a public company and thus a state actor. After that deal went through, she was required to attend a new training session or series of sessions that explained the university's policies for medical professionals when interacting with patients that identify as LGBT, which brings us to the controversy. So the training noted that she was expected to affirm statements concerning sexual orientation and gender identity that she says her Christian faith prohibited her from affirming. She requested a religious accommodation that would allow her to continue serving patients in a manner consistent with her faith as well as her professional medical judgment. Allegedly, Kloosterman's supervisors ridiculed her faith, called her a liar at one point, and eventually this led to her termination from her position. So in response, Kloosterman filed a 1983 action. That's a constitutional violation civil suit. We've discussed these kinds of cases many times before, alleging violations of her free speech, free exercise rights, as well as violations of the Equal Protection Clause. So I want to touch on two things. One, the substantive issue that underlies this case, and then I want to talk about the procedural outcome in this case, because it is actually quite important for cases like this moving forward. So on the substantive side, this is yet another case of coercion in the name of tolerance. We've talked about this a lot before, but it's really troubling when in the name of tolerance, people are pushed out of certain fields or professions, and no dissent is allowed, especially when that dissent or that disagreement is based on religious belief. So I just want to come out and say this is not about respecting or tolerating people who live lifestyles associated with the LGBT movement. This is about forcing people in certain fields of public life, here the medical profession, to speak and to act, and even in certain circumstances to think in a certain way. And that's a major problem and something that we're dealing with pretty consistently as watchers of religious liberty legal cases. So like we've had previous discussions around this issue on forced use of pronouns. So I want to say not only is this coercion, but it also seems like one of these things that's pretty much a non-issue, a solution seeking a problem to really enforce ideological purity rather than deal with a real issue involving patient care. When interacting with LGBT patients, really what possible need would a physician assistant have to, quote, affirm statements of any kind when interacting with these patients? I think with a little bit of care, Ms. Kloosterman and people in her position can certainly treat patients with respect if they identify as LGBT and tend to their medical needs without referencing their sexual orientation or gender identity or their pronouns really at all, right? You can show respect to a patient, but having to affirm their statements about sexual orientation or gender identity, it just seems like a non-issue to me. Joseph, when I finish on my second part, I'd be curious to hear if you have any thoughts on this. But I was thinking about this before we started recording, and I don't see how this would play out, right? If she's treating people for their medical needs and they make a statement about their orientation, about their identity, there's really no need to comment on it in order to give medical care. So I don't really see the issue. The second thing that I wanted to cover is the procedural outcome, which I think is really important and often missed in the headlines, right? This can be labeled as, a case about forced speech or coerced belief or what have you, and that's right. but this was ruled on based on a really important legal procedure. So here, the Sixth Circuit Court of Appeals ruled that Kloosterman's claims could not be dismissed after the university filed a motion to compel arbitration. Now, anybody familiar with the legal world, which is probably most of our listeners, know how this works. When you have a contract, probably including her employment agreement, you often have compelled arbitration clauses, which says that in the event that there's a legal dispute between the two parties, the employer in this case can compel arbitration and have a private arbitration panel rather than a public court decide the dispute. So what happened here, though, is that the university filed this motion to compel arbitration and thus dismiss the case after having litigated this case in court for over a year. And the federal court said, no way. Right. That's a paraphrase. They didn't actually say no way in their opinion. But federal law requires parties who want to dismiss a case out of court and force arbitration to, this is a quote from the court, live up to the promise to arbitrate. And the court says defendants cannot play heads I win, tails you lose by keeping arbitration in reserve just in case a court does not reject the entire case at the start. And that's clearly what's going on here, and it's a problem. It's legal gaming, and it's unfair to the plaintiff in this case. So I want to read a paragraph from the Sixth Circuit opinion, and then I'll give a thought or two and finish up on this topic. So the court here says, quote, the hospital defendants repeatedly asked the district court to dismiss all of Kloosterman's claims on the merits, right? This is in the litigation. But the court declined to dismiss several of them. Only at that point, after a year of litigation and after the defendants got a preview of how the merits might progress in court, did they seek to arbitrate. We conclude that this request came too late, primarily because the defendants sought to avoid arbitration altogether by asking for a complete judicial victory. Specifically, we hold that the defendants lost their right to arbitrate under the Federal Arbitration Act because their conduct put them in default proceeding with their requested arbitration. We thus reverse the district court's decision to dismiss this suit in favor of arbitration. Okay, so basically what's going on here, I think it's probably evident, but just to put it in layman's terms, the whole point of compelling arbitration is you have this option instead of going to court to resolve your dispute, to go to arbitration to resolve your dispute. But that's not what happened here. The hospital network agreed to go to court. And so I think practically what happened is you waive your right to compel arbitration, right? If a plaintiff files suit and you don't immediately move to say, no, 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 we're compelling arbitration per, the Federal Arbitration Act, per the contract, you're basically waiving that right. And you're saying, okay, we're going to let the courts decide this. But what the defendants were clearly trying to do is say, well, let's see if the court will just dismiss all of Kloosterman's arguments and we can just resolve this in court. That was a choice. But what they tried to do is have it both ways, right? To, as the court says, play heads I win, tails you lose. To say, well, let's see if we can win in court. Oh, looks like we're losing in court. Never mind. We want to compel arbitration. And what the Sixth Circuit said here is you can't do that. You can't have it both ways. Compelled arbitration is a choice. It's a choice that has to be made at the outset. It's not a second shot at winning when it looks like you're going to lose in the courts. So I think it's a good decision. I'm pleased to see that the Sixth Circuit called this out as like gamesmanship that is not fair to a litigant in this case, and that they closed this off. And then substantively, what this does is allows the Sixth Circuit case to continue and hopefully give us a precedential decision in a case where a state actor is basically shutting somebody out of a profession for living their religious faith in their job.
Yeah, so like you said earlier, with it being kind of a non-issue from the outset, like her, I don't know exactly what type of medicine she practiced, but she wasn't a clinical physician or a clinical psychologist. She wasn't somebody whose job was to affirm statements. So trying to say you have to affirm these particular statements, it isn't really something that would come up within her practice on a typical basis. So like you said, this isn't a matter of trying to treat people respectfully. This is a matter of trying to compel a particular type of ideological speech from a medical professional. And just kind of more broadly, this is another case that really shows how these procedural issues really quickly become religious liberty issues. We've talked in the past on this podcast about some very technical issues that became these massive questions relating to religious freedom. The Medina case was basically around a technical 1983 thing. We talked recently about the latest Apache stronghold development, which the religious liberty claim lost, but now there's like a procedural environmental law question. And the list could go on with how there are these very particular legal requirements that don't look like they relate to free exercise necessarily, but in result, they're directly tied to something about somebody's religious free worship, free exercise. And it goes to show the American legal system certainly has its imperfection, just like any body of laws. But there are protections deeply rooted in much of U.S. law and procedure, even in just what we're talking about here, right? We're talking about arbitration requirements. And at the kind of the end of the day, what's happening is this plaintiff is allowed to proceed with her lawsuit because her rights were infringed upon. So properly applying existing laws in the American legal system, quite often the result is a win for religious liberty. So we're always happy to highlight when the procedural question is accurately followed and it leads to a decision like this one. So with that, we'll move into our second update, which I was very happy to get to see because we've talked in the past about physician-assisted suicide, and I think right now 10 states have it legalized plus DC, and it's pending in 2 different states. Right now in New York, it's just pending the governor's signature to legalize it across the state. So what we're going to talk about next is a bill that would kind of be the virtuous counterpart to physician-assisted suicide, and that would be palliative care and hospice. So palliative care, for anyone unfamiliar, it basically seeks to relieve the symptoms, pain, or stress from chronic illness. It's not necessarily going to, if somebody has a terminal diagnosis, sometimes there's not really much a medical professional can do. Palliative care tries to improve their quality of life as well as their family from a physical, emotional, even spiritual at times perspective. So it really sees a person with a terminal illness as a person, and it tries to alleviate their suffering and give them kind of the dignity that they deserve to be treated with. So the bill itself, which it's currently pending, I think it's in committee in the Senate right now, and there's I think an identical bill in the House, where its purpose is basically to amend the Public Health Service Act in order to expand palliative care and funding and research for it. It does so in a few main ways. The primary one is through funding different expansions and trainings for hospice and palliative care. And also hospice, for anyone unfamiliar, is a similar kind of manifestation of palliative care. It's treating people not so much to fix the illness that they have, but to make them as comfortable as they can be as they battle through it. So basically, the bill would give contracts and grants to a number of medical institutions, basically to fund palliative care training and programs within that. So there'd be like a fellowship program for current medical faculty that want to receive additional training. There'd be more efforts to integrate hospice and palliative care into just medical primary care practice. A lot of times, their medical practitioners don't actually do it. So there are efforts to try to bring it into the kind of the umbrella of typical medical practice. There's also efforts just to increase awareness across the board of what palliative care is and it as an option. So part of the way it would do this is it would give career awards to individuals that do this well. So if somebody has a renowned career of performing palliative care, they would be able to be recognized under this bill. It funds outreach to communities without access to palliative care. So if there's really nobody that provides this sort of thing in a certain area, this would try to make that more of an option. And lastly, it expands some current existing National Institute of Health research, really just to try to see how can we do this thing better? How can we better address those? How can we better address the needs of those with chronic illness without just seeing them as somebody who can just kind of be done away with, right? So the recent update was the USCCB recently issued a letter stating its support along with the Catholic Health Association. And a really big thing that they noted that I wanted to make sure we talked about now is that in the proposed bill, it clarifies that no funding can be sent to a program that facilitates assisted suicide or euthanasia, in accordance actually with an existing law from 1997. So it says no funds appropriated by Congress for the purpose of paying for the provision of healthcare services can be used to go to any service that provides euthanasia, assisted suicide, or mercy killing. So we're really glad to see the kind of the virtuous way to treat an individual that is suffering from a chronic illness, getting a little bit more steam and support in the face of kind of this counter movement of expanding access to this really terrible practice of assisted suicide.
Yeah, I mean, I 100% agree. This is a really important way to counter a pro-death movement, frankly. And I think you alluded to this, but it's similar to the efforts of, pro-life pregnancy centers in the abortion culture. Like, okay, we have this massive cultural movement toward a culture of death, whether that's abortion or physician-assisted suicide. So not only how do we stop it, but like, how do we put a stop to the bad practices, but how do we fund good alternatives is a really important question that is right within the scope of the proper role of government, right? So it's really heartening to see federal movement, and hopefully this bill will move forward. But and again, to find creative ways, not just to immediately initiate good practices, but to make them aware, right? To give doctors this option to have training, to have public support and knowledge of the alternatives, right? Because one of the things that we see in the abortion culture all the time is that a lot of people choose abortion not because they think it's a positive good, but because they feel like they have no other option. So just presenting good options that promote human dignity and ultimately are better for the individuals, that's a good thing. And it's something that should be what we do with our government funding, right? I think it's a good general principle, and we'll talk about this in our final issue in a minute, but it's good to defund what is bad, right? We've seen a lot in the last 8 months now of this administration, almost 8 months of rooting out uh, public funding for things that are really evil and bad for society, and also efforts to fund what is good for society. That's really heartening to see. It's not just about efficiency. I'll talk about this when we get to the DHS issue, but it's not about being more efficient in the way that we spend funds, but in actually having substantive conversations about what it is good to fund, right? If we're efficiently funding, right, cutting waste and cutting excess, but at the end of the day, we're more efficiently funding bad programs, that's still bad. So seeing something like this, an initiative to fund something that's really important for a good pro-life society, that's a really good thing. And I would say this is good. The palliative care, hospice care movement is good for everyone involved. I've talked about this on physician-assisted suicide in the past. I think on the episode I recorded with Nathan Berkeley a couple months ago, that physician assisted suicide is bad for the dignity of everyone involved, right? For the sick people themselves who are encouraged to end their own lives rather than suffer with dignity, and also who are pushed to feel like maybe they have no choice and would be less of a burden if they kill themselves. Um, Physician assisted suicide is bad for family and friends of sick people because it gives them this really evil option to dispose of people who are a burden rather than giving them the opportunity to love and care for the sick and the suffering. And then lastly, physician assisted suicide is really bad for doctors who are supposed to be taking an oath to heal and to do no harm, and instead are being asked to cooperate and actually doing the opposite of that, which is killing or assisting in killing their patients. So while physician assisted suicide is rather sinister, this is the flip side and is really a great way to bolster the human dignity of everyone involved, right? For sick people, it gives them an opportunity to spend their last weeks, months, however long they have, with dignity, being managed humanely, right? Their symptoms are cared for, the pain relief and everything is on the table, as well as psychological treatment and spiritual treatment to help them embrace these important last days of their lives with dignity. It's better for family and friends, right? Who, like I said, instead of being encouraged to dispose of a family member going through difficult time, not to isolate them and to kind of push them toward physician assisted suicide, but to help them to die humanely and also to be a part of it, right? To let somebody take lethal drugs and end their own life just seems such an awful, isolated way to end your life, right? Basically, you're a burden, take these drugs and everyone's life is better. That's just so awful to hear. So on the flip side, what this allows is for family and friends to see that their sick loved one has their pain managed, has their spiritual needs taken care of, and that they can be a part of those important last days, right? Family and friends can be at the bedside, can visit, can help to encourage their loved ones as they die. And then finally, this is just a huge boost for human dignity for doctors, right? This is a real living embodiment of what it means to heal and to do no harm, right? To accompany people who are dying rather than killing them or aiding them in dying, to be able to walk with them in a humane and rather beautiful and profound way as they're dying. So to me, this is the mirror image, the flip side in a good way of the whole medical aid in dying, physician-assisted suicide, euthanasia movement, and really affords an opportunity for everybody to live with more dignity and to embrace death beautifully instead of, you know, accelerating it to avoid the pain and suffering that nobody wants, but that is part of life.
Yeah, so palliative care, like you said, broadly speaking, it does treat everybody in the situation how they should be treated and enables them to treat others in like manner. In this bill in particular, also just to highlight kind of some of the workings of this actual legislation that's pending now, um, it does the exact same thing, right? There's training and recognition for medical providers themselves, either who already do this well or want to learn how to do it well. A big part of this bill itself is also training for family members on how to give care at home and then how to be a good like accompanier for people suffering in this way. So there's training for medical practitioners, there's training for family, there's also actual support and funding for family members. And then obviously it all comes down to giving the correct type of treatment and the correct type of love and care for a terminally ill patient that it needs.
Yeah, so as we wrap up, let's talk about another shift toward government spending toward good things. So the Department of Homeland Security recently issued a series of grants to faith-based organizations to bolster their security. And it's a really interesting and I think timely award. There was a grant of, I think the amount of money appropriated by Congress is about $200 million for these security initiatives. There was recently an award of about $110 million to over 600 faith-based organizations to enhance their security systems. So the funds are going to a wide variety of religious organizations, churches, synagogues, mosques. There are a wide variety of religious organizations actually involved, but it also does extend beyond houses of worship for reasons that I'll get to in a second. The funds are restricted to a number of security enhancements, additional security cameras, staff training for emergencies, alert systems, and so on. So in earlier this summer, a lot of that money went to a number of Jewish organizations in the face of I think we don't really have to go into why there were security concerns for Jewish organizations given the protests and things that have gone on and acts of violence over the past 2 years against Jews in particular. There was a senior DHS official as this money went out that stated whether the faithful, pray in a church, a mosque, or a synagogue, all Americans should be able to practice their religion without fear of terrorism and violence. So it's interesting to note a couple things. For one, these grants come amidst greater scrutiny in the use of federal dollars. Like we said, there's been a lot that's been under the eye of government where bad programs are being defunded. And so government funds, they do have a rightful place, and securing the safety of Americans is one of them. And that should include those engaged in religious practice, right? So I think this is an interesting and encouraging shift in government spending. And I just want to highlight two things that I see from this particular grant for faith-based organizations' security measures. For one, as I said earlier, we don't want our tax dollars funding things that are bad for society. So close scrutiny on where government is spending its money is a good thing. One of the issues in this vein that was highlighted early on in this Trump administration was the USAID spending, right? That right at the beginning of the new administration, there was a lot of scrutiny on USAID, and a lot of those programs were scrapped. February 3rd, the White House actually published something on USAID spending that I think is worth just highlighting, because often what happens in these things is critics say, well, they're just scrapping government funding of important programs and what's happening to all the good initiatives that are being funded. And I mean, there's so much, again, not just waste and inefficiency, but bad things being funded. I think those things need to be called out very specifically. So the USAID publication that the White House put out on February 3rd, I think highlights some really interesting things to just shed some light on this. This isn't just like feeding the hungry, housing the homeless, helping people in disasters, right? In the USAID programs that were scrapped, the White House points to a series of things that I just want to point at a few of them. There were spending appropriations for $1.5 million to advance diversity, equity, and inclusion in Serbia's workplaces and business communities, $70,000 for production of a DEI musical in Ireland, $47,000 for a transgender opera in Colombia, $32,000 for a transgender comic book in Peru, and $2 million for sex changes and LGBT activism in Guatemala. I think it's worth pointing to these things, right? So much money gets spent via the federal government that sometimes it can get lost, right? It's hard to even pay attention to all of it to really scrutinize where it's going, because we spend billions and billions of dollars both at home and abroad. So I'm glad personally to see government and media scrutiny start to question and claw back spending that's, again, not only wasteful or inefficient, but actually promoting bad things. So on the flip side, we're seeing a shift away from the inclination to exclude funding from religious organizations and to start not just cutting back government spending, but shifting government spending to those things that are good and necessary and rightly ordered toward the common good. So, particularly in the religious sphere, we've pointed out constantly on this podcast that recent First Amendment cases, especially the free exercise line of cases leading up to Carson v. Macon, make it pretty clear that excluding people or organizations from generally available government programs solely because of their religious identity violates the free exercise clause. Yet we've seen a lot of this, right? We've seen all the school cases that we've talked about, right? Voucher programs that are open to all private schools unless they're religious. That's been pretty widely struck down by cases from Trinity Lutheran to Carson v. Macon. In the FEMA area, there's been in the not so distant past an exclusion of houses of worship from receiving grants to engage in disaster relief efforts. But the tide is turning on these things, right? That house of worship exclusion from disaster relief was, I believe, revoked in the first Trump administration around 2018. So we're seeing a real scrutiny of this. If there are these generally available programs, religious organizations should have a seat at the table. So in this particular case, seeing funding for security measures for houses of worship, but also other religious organizations is timely, both because excluding them, I think, violates the First Amendment, but also we're practically seeing increasing violence at religious organizations, right? Places of worship, there have been acts of violence increasing at churches, at synagogues, at places of worship in recent years. We just had that horrible shooting in Minnesota. Now it'll be about a week or a week and a half ago by the time you're hearing this. So these are not random, pro-religious initiatives for their own sake. These are responding to real problems in the community. And also outside of houses of worship, right? We've seen in the wake of the Dobbs decision overturning Roe, there were fire bombings of pro-life pregnancy centers. These are real problems, not to say anything of the Jewish organizations that have been under violent attack since October 7th, 23. So I'll conclude with that. What the government chooses to fund should be linked to what is good for society. So seeing the defunding of bad and woke initiatives is good. Seeing the increased funding of protection for religious exercise is also good. And this is responding to a real need. The kind of woke left, if you'll allow me to use that term, has been increasing its violence against religious organizations and religious exercise. And so seeing the government step in and say, we fund security, we fund public order and safety, and religious organizations are under attack, and we're going to make that a priority in our federal spending, to me is a great development.
Yeah, like you said, this fits into a broader pattern of federal money, A, not going where it shouldn't, and B, being able to go where it should. And as a religious organization or nonprofit, accepting government money certainly can be a prudential decision, right? Even when they're not always visible, money has strings attached. If an organization might not want to become dependent on government funding, because then let's say the political winds shift and you get that cut out from under you. If you're not able to sustain yourself anymore, you could be in serious trouble. But regardless of the prudential kind of side of things, it's good to see a more proper understanding of the government's role in society being affected in policy. It's not a constitutional issue, as we've seen time and time again. It is not a constitutional issue for the government to treat a religious organization fairly. And I think that these sorts of grants that we're seeing from DHS, we saw recently from SBA, it fits that pattern of it's okay to treat religious organizations even-handedly. In fact, it's necessary.
Yeah, that's right. I think again to beat a dead horse here, the Establishment Clause violation comes if the federal government says, okay, we're going to establish that FEMA is going to grant money like primarily to the Episcopalian Church, and that's going to be our religious arm for disaster relief efforts, but they're going to exclude like Catholic churches or Baptist churches. That's an Establishment Clause problem. If these security measures are okay, we have a grant particularly for Jews, for Jewish organizations, but no other religious organizations can apply, maybe an Establishment Clause problem, right? But that's not what this is, including religious organizations generally in generally available public programs is not, and I repeat, is not an Establishment Clause issue. So with that, we thank you for joining us for this episode of the Napa Legal Podcast. If you enjoy the content we're putting out, we would appreciate it if you like the podcast, subscribe to our channel on YouTube, Spotify, or wherever you're listening from. And if you'd like to support the work we are doing, we always appreciate your support and your contributions. You can donate to the efforts of Napa Legal on our website at napalegalinstitute.org. We hope you'll join us next week as we continue to highlight and discuss some of the most important ongoing legal issues that affect religious liberty, and particularly the work of faith-based nonprofit organizations. We'll talk to you all next week. Thank you for joining us, and God bless you all.